Okay, let's dive right into this. Today, we're unpacking one of the most high-stakes legal dramas in modern history. We're looking back at a really profound moment in South Africa's journey, examining a landmark judgment from the Constitutional Court back in 1998. And look, this isn't just some story about sports administration. It is an absolute masterclass in how a young democracy tests the very boundaries of its power. I want you to just picture this for a second. You've got a sitting head of state, and not just any head of state, but the globally revered Nelson Mandela. He is challenged in a local court, literally forced to testify, and then told by a single judge that his executive actions are legally invalid. I mean, wow. How does a brand new democracy operating with a freshly minted constitution handle such a massive collision between the executive branch and the judiciary? That's the ultimate test of power we're exploring in this explainer. Here is our roadmap for the explainer today. We're going to cover 1. The Mandela rugby clash. 2. The High Court drama. 3. A jurisdictional tug-of-war. 4. Decoding the Constitution. And finally, number 5, the final verdict. Starting with part 1, the Mandela rugby clash, setting the stage for a crisis. Let's move through the timeline and see how this all builds up, because to understand this legal puzzle, you really have to see what triggered it. Back in September 1997, President Mandela appointed a commission of inquiry to look into the financial and administrative affairs of the South African Rugby Football Union, or SARFU. He believed the new constitution gave him the power to do this, but SARFU fiercely objected. Literally a month later, they went to the Transvaal High Court to get this appointment thrown out. Fast forward to January 1998, and things just escalate dramatically. The president is actually forced to take the witness stand. Then in April, the High Court drops a total bombshell and invalidates his actions entirely. It wasn't until December 1998 that the Constitutional Court stepped in to untangle the whole mess. It was just a breathtaking escalation of legal and political tension. That brings us to part 2, the High Court drama, a president on the witness stand. To really grasp the shockwaves of what went down in that courtroom, we need to bust some legal jargon early on and understand a massive concept, an order of invalidity. So, this is a ruling from a court declaring that a specific action, a law, or official conduct is fundamentally unconstitutional. When a court hands down this order, it's basically saying the action has zero legal force, it's completely void. And amazingly, that is exactly what Judge de Villiers did. During the court recess, no less, he made an incredibly rare, almost unthinkable order requiring the sitting president to give oral evidence. Mandela actually complied and was cross-examined on the stand. Then, on April 17, 1998, the High Court formally set aside the president's decision. Honestly, it is hard to overstate how wild this was. You have a single, local judge looking at the executive actions of Nelson Mandela and saying, "Nope, this is void." And the judge didn't even provide his reasons right away. Those came months later in this enormous judgment that ran over 1,000 pages. Moving into part 3, a jurisdictional tug-of-war, navigating the maze. Now, what's really interesting here is that South Africa in 1998 was such a new democracy that the rule book was literally still being written. The specific laws dictating exactly how you go about appealing an order of invalidity against the president hadn't even been promulgated yet. So this caused massive procedural confusion. It led to some unavoidable delays for the president's legal team, which meant that when they did finally file, they had to beg for condonation. That's just a fancy legal way of asking the court to forgive you for missing a strict deadline because of extenuating circumstances. But that delay opened the door for a massive turf war between two legal heavyweights, the Supreme Court of Appeal and the Constitutional Court. The respondents in this case, SARFU and Dr. Louis Loit, heavily opposed the president's late appeal. And so it became this fierce debate over which court actually had the authority to review a high court's invalidation of a president's conduct. SARFU tried to spring what was, honestly, a pretty brilliant procedural trap. They argued that the president's team had effectively waived their right to go to the Constitutional Court. Why? Well, because months prior, before the procedural rules were even clear, the president's team had filed a precautionary application for leave to appeal to the Supreme Court of Appeal. SARFU argued this was a firm election. They were saying, you made your choice, and that locks you out of the Constitutional Court entirely. This brings us to part 4, decoding the Constitution, the apex guardian. To resolve this turf war, the Constitutional Court had to step up as the ultimate umpire. When you distill the dense text of the Constitution, it basically boils down to 2 vital rules. First up, Section 167(5). This dictates that the Constitutional Court makes the final decision on whether the conduct of the president is constitutional. Second, you have Section 172(2)(a), which states that if a lower court makes an order of invalidity against the president, it has absolutely no force until the Constitutional Court actually confirms it. So lower courts simply cannot have the final say on executive power. And this brilliantly illustrates a concept the applicant's legal team described as a limping invalidity. Because Section 172 clearly states an order has no force unless it is confirmed, the High Court's ruling against the president was trapped in this weird state of limbo. The High Court had technically struck down the president's actions, sure, but until the Constitutional Court weighed in, that ruling couldn't fully walk on its own 2 feet. So you might be wondering, why did the framers of the Constitution design it exactly this way? Well, it all comes down to one word: comity. This rule is specifically designed to preserve mutual respect and harmony between the different branches of government. It stops lower courts from intruding on the domains of the executive branch. Ultimately, it vests the supervisory duty to check the president's power strictly and exclusively in the highest court in the land. Finally, Part 5, the final verdict. The court steps in. Led by Judge Shaskelson, the Constitutional Court didn't actually rule on whether Mandela was right or wrong about the Rugby Commission just yet. Instead, they focused entirely on authority. So the crucial point is, they granted condonation, forgiving that late filing, and crucially, they claimed exclusive jurisdiction over the whole matter. They flat out rejected SARFU's argument that the appeal belonged in the Supreme Court of Appeal, declaring that when it comes to the constitutional validity of a president's conduct, parties have an unqualified right to appeal directly to the top. These final rulings really drew a clear line in the sand. Condonation was granted. The court ruled that the president definitely did not waive his rights by previously looking to the lower court. They affirmed that this wasn't just some minor factual dispute. It was a massive constitutional issue of substance. They made it explicitly clear that calling a sitting president to testify is absolutely a matter exclusively for the highest court to review. And by doing all this, they set the stage for the actual merits of the case, the real deep dive into the evidence, to be vigorously debated a few months later in March 1999. As we wrap up this explainer, I want to leave you with a pretty provocative question. When a president is taken to court, who truly holds the ultimate power, the leader or the law? This 1998 clash brilliantly demonstrated that in a constitutional democracy, even the most revered leaders are subject to judicial review. But at the same time, it showed that such immense power to invalidate executive action has to be carefully guarded by the highest court to ensure balance. It is just a fascinating look at the mechanics of justice and the rule of law. Thanks so much for joining me on this deep dive, and keep questioning how the structures around us really work.